breaking news tonight: Supreme Court has just taken a monumental step toward permanently ending every so-called assault weapon ban in America. This isn't just another legal update, this is the moment gun rights advocates have been fighting for over a decade. For millions of law-abiding citizens, this could be the turning point that restores what they see as the true meaning of the Second Amendment. If this decision holds, years of restrictions, bans, and political battles could vanish almost overnight. The implications are massive and the nation is already reacting. So what exactly did the court just do, and how close are we to a permanent victory for gun rights in America? Stay tuned because this could redefine the future of firearms and freedom itself. This all began with a series of challenges to state-level assault weapon bans that have been on the books for years, some for decades, in places like California, Illinois, New York, Connecticut, Maryland, and Massachusetts. These bans targeted semi-automatic rifles, the kind that look scary to politicians but function exactly like countless other firearms that are perfectly legal. They banned magazines over certain capacities. They created lists of prohibited features: adjustable stocks, pistol grips, flash suppressors, things that have nothing to do with how dangerous a firearm actually is and everything to do with how politicians and gun control activists feel about them. Gun rights organizations have been challenging these bans in federal court for years, arguing that they violate the Second Amendment, that they ban firearms that are in common use by millions of Americans for lawful purposes like self-defense, hunting, and sport shooting. But here's the problem: they kept running into lower courts, were split. Some federal judges would strike down the bans, recognizing them as unconstitutional. Others would uphold them, bending over backwards to find ways to justify government restrictions despite clear Supreme Court precedent. This created chaos, a patchwork of conflicting rulings across different federal circuits, different states operating under completely different constitutional standards. After months of this gridlock, after watching lower courts either ignore or misapply Supreme Court precedent, the Supreme Court finally stepped in. And their move signals something massive, something that should make every gun control advocate nervous and every Second Amendment supporter hopeful. The justices are tired of states ignoring Bruin and past rulings. They're tired of lower courts playing games with constitutional rights, and they're ready to settle this once and for all. So what did the court actually do? Let's be precise here because the legal mechanics matter and the implications are enormous. The court didn't just delay consideration of these cases. They didn't just add them to a list to maybe think about sometime next year. They pushed forward the review process. They expedited it. They signaled that this issue is a priority, that it needs resolution, and that they're prepared to issue a definitive ruling. That means a formal decision to end these bans, to declare them unconstitutional once and for all, is now in motion. The gears are turning. The legal machinery is engaged. And barring some unforeseen development, we're heading toward a Supreme Court opinion that could reshape gun laws across the entire country. This is the biggest advancement in Second Amendment litigation since the Bruin decision itself, the landmark 2022 ruling that fundamentally changed how courts must analyze gun laws. We're watching the groundwork being laid for a nationwide precedent, a ruling that doesn't just affect one state or one type of ban, but one that could permanently erase the phrase assault weapon ban from American law. Think about what that means. States couldn't just rename the law or tweak the language. They couldn't play word games or find creative ways to ban the same firearms under different legal theories. The justices are relying heavily on Bruin, the case that redefined how courts must interpret the Second Amendment and how they must evaluate any law that restricts gun rights. Before Bruin, courts used something called interest balancing, where they would weigh the government's interest in public safety against the individual's right to bear arms, and surprise, the government usually won. But Bruin changed everything. The Supreme Court said that's not how constitutional rights work. You don't balance them away. You don't let judges decide whether a right is worth protecting based on their personal policy preferences. Instead, the court established a clear historical test. If the government wants to restrict gun rights, it has to show that the restriction is consistent with the nation's historical tradition of firearms regulation. It has to point to laws from the founding era, from the time when the Second Amendment was written and ratified, that imposed similar restrictions. And if the government can't do that, if there's no historical precedent, then the law can't stand. It's unconstitutional, period. And that's the fatal problem for states like California, New York, Illinois, and all the others with assault weapon bans on the book. There is no historical precedent for banning common, modern firearms that are owned by millions of Americans. The founders didn't ban muskets that looked scary. They didn't create lists of prohibited features. They didn't tell citizens, you can have this gun, but not that one, because we don't like how it looks. The idea would have been absurd to them, a blatant violation of the right to keep and bear arms. Almost immediately after the Supreme Court's move became public, the Department of Justice and gun control groups went into full panic mode, and I mean absolute, unrestrained panic. Press releases started flying. Spokespeople started giving interviews. Statements were issued condemning the court's action in the strongest possible terms. They're calling this move reckless, dangerous, and even life-threatening. They're predicting that if assault weapon bans fall, America will descend into chaos, that violence will explode, that the streets will run red with blood. It's the same fear-mongering playbook they always use, the same apocalyptic rhetoric designed to scare people into surrendering their right. But here's the thing: their outrage, their panic, their over-the-top condemnations only prove one thing. They know what's coming. They can read the tea leaves just as well as anyone else. They see the Supreme Court's composition. They see the precedents set by Heller, MacDonald, and especially Bruen. And they know that if this case continues forward, if the justices apply the law as written and the Constitution as intended, their last major tool for restricting lawful gun ownership will collapse. The assault weapon ban has been the crown jewel of the gun control movement for decades. It's been the policy they point to when they need to show they're doing something, the restriction they defend most fiercely, the hill they're willing to die on. And now that hill is crumbling beneath their feet, California, Illinois, and New York officials are already strategizing, already holding emergency meetings with their legal teams, already talking about emergency legislation, executive orders, anything they can think of to delay enforcement of a potential Supreme Court ruling. Governors are making statements. Attorneys general are drafting memos. State legislators are floating ideas for new laws that they hope will somehow comply with the Supreme Court's ruling while still restricting as many guns as possible. But the truth is, and deep down they know this, the Supreme Court has made it crystal clear that states can't pick and choose which parts of the Constitution to follow. You don't get to say, well, we like the First Amendment and the Fourth Amendment, but the Second Amendment doesn't really apply here because we have different values. That's not how constitutional rights work. They're not suggestions. They're not guidelines. They're the supreme law of the land, binding on every state, every city, every government official in America. And what we're seeing right now, in real time, as these blue state governments scramble and panic and search desperately for loopholes, is the beginning of a constitutional reckoning. Gun rights leaders from organizations across the country, from Gun Owners of America to the Firearms Policy Coalition to the National Rifle Association and beyond, are calling this a once-in-a-generation shift in the legal and political landscape. The energy, the excitement, the sense of momentum in the Second Amendment community right now is absolutely electric. These organizations have been fighting in courts, in legislatures, in the court of public opinion for decades. They've won some battles and lost others. They've seen progress and setbacks. But this moment we're living through right now feels different. It feels like the culmination of decades of work, decades of advocacy, decades of refusing to give up even when the odds seemed insurmountable. The Firearms Policy Coalition issued a statement that read, and I'm quoting directly here, This decision signals that bans on commonly owned firearms are on borrowed time. The Supreme Court is preparing to do what lower courts have refused to do: apply the Constitution honestly and protect the rights of millions of Americans. That statement has been shared tens of thousands of times. It's resonating because it captures what so many gun owners are feeling right now: hope. Real, tangible hope that the Second Amendment will finally be respected, that decades of infringement will finally be rolled back, that the phrase, "shall not be infringed," will finally mean something again. Gun rights groups are already preparing for what comes next. They're identifying the next wave of unconstitutional laws to challenge. They're mobilizing their members. What happens next? That's the critical question, the one that everyone from legal scholars to gun owners to politicians trying to position themselves for the next election is asking right now. Here's what's next, based on how these cases typically proceed and what the signals from the Supreme Court suggest. The court could now move this case into full briefing, meaning both sides would submit detailed written arguments, the justices would hear oral arguments, and then issue a full opinion explaining their reasoning and the scope of the ruling. That process takes time, usually several months, but it results in a comprehensive precedent that lower courts must follow. Alternatively, and this is where it gets really interesting, the court could issue what's called a summary reversal. That's when the Supreme Court looks at a lower court decision and says, "This is so clearly wrong, so obviously inconsistent with our precedent, that we don't even need full briefing. We're reversing it right now." If that happens, the bans fall instantly. Not in 6 months. Not after another round of litigation. Immediately. Gun owners in California, New York, Illinois, and every other state with these unconstitutional restrictions would be free to exercise their Second Amendment rights, and state governments would be powerless to stop them. But even beyond the immediate impact on assault weapon bans, this decision would set a precedent for every future gun law challenge. It would establish once and for all that commonly owned firearms cannot be banned. It would make clear that the historical test from Bruin is not a suggestion, it's a requirement. It would embolden gun rights groups to challenge every remaining restriction: magazine capacity limits, carry permit schemes, gun-free zones, you name it. Tonight's news isn't just about policy, isn't just about which laws are on the books or which restrictions get struck down. It's about principle. It's about whether we're going to be a nation governed by the Constitution, or a nation where rights exist only at the sufferance of politicians who don't like them. And if this ruling holds, if the Supreme Court follows through and strikes down these assault weapon bans once and for all, it will mark the biggest victory for gun rights in modern American history. Not just since Heller. Not just since Bruin. We're talking about a generational victory, the kind of win that changes the trajectory of constitutional law for decades to come. But here's the reality, and I need you to understand this: the fight isn't over. The DOJ is already looking for ways to resist. Blue states are already planning their next move. Gun control groups are already fundraising off the outrage, already planning their messaging, already preparing for the next battle. This is a marathon, not a sprint, and the other side isn't going to give up just because the Supreme Court says they're wrong. So stay alert. Stay informed. Subscribe to this channel if you haven't already, because we're going to cover every single step of this fight, every development, every reaction, every implication. This is history unfolding in real time, and you're witnessing a moment that will define the future of freedom in America. The Supreme Court just took a massive step toward vindicating your right. Now we wait to see if they finish the job.